This is Michael Popok, Legal AF, with some breaking news and analysis. The number one criminal charge used by the Department of Justice, that of obstruction of an official proceeding, carrying with it a 20-year term against the Jan 6 insurrectionists, may be on life support, based on the oral argument today at the D.C. Court of Appeals in the case of Fisher and the United States. In that case, Judge Nichols, Carl Nichols, a Trump appointee, had ruled that the federal government, the Department of Justice, had overstepped and was improperly applying the obstruction of an official proceeding charge to the facts of the case. His argument and his ruling in dismissing the obstruction count against Mr. Fisher was that unless there was evidence that Mr. Fisher interfered with the actual ballot counting of the Electoral College count at Congress, he could not be so charged. That could have, if carried forward to the other 300 Jan 6 insurrectionists that have been charged with obstruction of official proceeding, including a handful that have already been convicted of that, including Stuart Rhodes and Kelly Meggs of the Oath Keepers, if you rip away that count, that crime, from the prosecutor's arsenal, now in the hands of, ultimately, with Jack Smith, it could have devastating impacts both on how many years, primarily, these people, having committed these heinous crimes, are going to serve in a federal prison. If you don't have the 20-year count, you're down to other charges that are between 5 and 10 years, which ties the hands, of course, of the trial court in sentencing. How do we know that this is probably a count that may be in jeopardy? Based on the oral argument that went off today for almost an hour and a half with Nick Smith, a lawyer who's been representing dozens of Jan 6 insurrectionists, against Jim Pierce for the Department of Justice. These two have tangled before in other courtrooms in Washington, D.C. on these very issues. Every time there is an indictment, Nick Smith steps up to a podium in a courthouse, in a courtroom, and argues that the obstruction count should be dismissed. Now, he hasn't been successful in other courtrooms. Every other judge in the federal courthouse, in the federal district courthouse in Washington, except for Judge Nichols, the Trump appointee, has agreed that obstruction is being properly applied by the Department of Justice and should be a count that goes to the jury. But this appeal will decide, at least at the intermediary appellate level, once and for all, whether the Department of Justice can continue to use obstruction as their main hammer in their arsenal against the insurrectionists. So the argument today really showed where the battle lines are drawn. Judge Katsas, you can count him already as a no vote to reverse Judge Nichols. In other words, he'll be in favor of Judge Nichols' decision to dismiss the obstruction count. He already showed his hands in questioning by saying, well, if you look at the legislative history of the 2002 law that the obstruction count, it was when passed by Congress. That was passed by Congress to address something in particular, corporate fraud in the wake of the Enron collapse and scandal. And Jan 6 may be many things, Judge Katsas said, but corporate fraud is not one of them. And I think stretching this case, this crime, to fit this case is too far and violates legislative intent of Congress when they passed the law. Of course, the Department of Justice argued right back that laws get passed by Congress all the time, and they can be applied under different factual scenarios to fit the actual crime that's been performed. If it's on the books, the Department of Justice can apply it, and you don't have to go all the way back to legislative intent to say that, well, it only applies in corporate fraud. Judge Pan, the Biden appointee, definitely is in favor on the other side, it looks, based on her questioning, in keeping the obstruction count in the arsenal of the prosecutors and find that Judge Nichols made an error, reversible error, in dismissing that particular count. The one in the middle, the swing vote, is going to be Judge Walker, the Kavanaugh apologist and former clerk. Based on his questioning, he certainly did not like or enjoy and took umbrage at Mr. Smith's arguments on behalf of the Jan 6 insurrectionists that all they did was similar to what all of the lawyers and protesters who descended on Florida in 2000 in Bush versus Gore. It's the same darn thing, is what Mr. Smith said during his oral argument. And if those people, those lawyers who were objecting to the vote counting and the balloting about Gore versus Bush and Bush versus Gore, why weren't they charged? And couldn't they be charged with obstruction in that count? And even Judge Walker put his hands up and said, stop. You can't compare the lawyers and the protesters, the peaceful protesters who descended on Florida from outside the state in order to supervise the vote counting, to object to the vote counting, to go to court about the vote counting. You can't compare them to Jan 6 insurrectionists like your clients who physically attacked, violently attacked with bloodlust, Capitol Police, went after elected officials, tried to drag them by their hair and string them up in a noose. You're not comparing those two things, are you? And that's an example of an advocate in Nick Smith not reading the room. If he had read the room and done his research about the panel, he would have realized that he had already stepped into a bear trap and would have avoided it with Judge Walker, because Judge Walker was a close friend and supporter of Kavanaugh, and Kavanaugh was one of the lawyers who descended on behalf of the Republican Party on Florida in 2000 in order to support George Bush. That is the wrong example and analogy to use, and Judge Walker let him have it and told him that that is not a comparison, that what happened, the violence that happened in the attack was unprecedented, and that led Judge Pan to comment, yes, and in unprecedented times, the prosecutor has to be free to apply laws that are on the books, even under fact patterns that weren't anticipated or contemplated by Congress. So that was the debate going on in the oral argument. Now, sometimes it's hard, generally it's hard to decipher whether the oral argument and the way judges have staked out their positions based on questions is going to pan out, no pun intended, in the result. But here, I think it's safe to say, and I won't be going out on too far of a limb to predict, that when this vote comes out, Judge Pan will be in favor of reversing Judge Nichols and putting the obstruction count back with the prosecutors to use in all their cases. And Judge Katsas will be on the far extreme, and he will find that Judge Nichols did the right thing in dismissing that count, and that it should only be used in corporate crime scenarios, not in insurrection type scenarios. And then the swing vote is going to be Judge Walker, based on his taking umbrage and being upset with Smith about comparing the 2000 Bush versus Gore to the Jan 6 insurrectionists. That didn't go well for Smith. He certainly stepped in the bucket and stepped on his own crank there. But now, when you get down to the law, based on other questions that Walker asked, he may be siding more with Katsas and against Pan in terms of finding that the law has been improperly applied to the facts of this particular case by the prosecutors. And we could easily have a 2-to-1 vote that would prevent the Department of Justice from ever using this type of count, which is their major hammer, 20-year felony, in any kind of fact pattern, if we ever unfortunately get it again, that's similar to an attack on the Capitol or an insurrection. And that would be a devastating blow to the Department of Justice and their ability to obtain justice for the American people and for all those that were violently attacked, and the interference with the peaceful transfer of power. Of course, it'll go to the Supreme Court, but if it goes to the Supreme Court on a 2-to-1 vote with two Trumpers in the two, one of them being supremely close to Judge Kavanaugh, who we know will not recuse themselves, I don't think that statute and the application of it by the Department of Justice is going to fare well if it gets all the way up to the U.S. Supreme Court, given its complete right-wing and Trump leanings of that court. They would likely support a 2-to-1 decision with Katz and Walker in the majority against the Department of Justice. We'll have to look at those things closely, but I'm very troubled by the oral argument today and by how the 3-judge panel could shake out. And I'm not the only one. It was noted that there were a number of federal prosecutors who were handling the 900 or so prosecutions, 300 of which have in their cases obstruction counts, some of which have already led to convictions on obstruction, which would have to be reversed by judges if these counts are found to be invalid and illegal. They'll be thrown out. It'll be one thing that Stuart Rhodes and Kelly Meggs will win as Oath Keepers. They will have their obstruction counts reversed and vacated from their sentences. And so, a number of the prosecutors who are line prosecutors handling these cases day to day sat there with great interest, leaning over the railing and watching because of how it impacts their work and their prosecutions, as were a number of FBI agents who were involved with the prosecutions. So I don't want anybody to think this was sort of just a esoteric academic debate going on of no real interest. This has tremendous interest to the Department of Justice to make sure that these three panelists get it right. And if they don't get it right, I would expect that the Department of Justice asks for a full review of all the members of the D.C. Circuit, which trend to be a little bit more Democrat, more Obama, Clinton, and Biden appointees than Trump appointees and Bush appointees. And I think they have no choice if they lose 2-1 and their ability to use obstruction as a count is on life support. I think they have no choice, the Department of Justice, but to ask for a full en banc review. If they prevail with a majority ruling on the en banc, then they're done, subject to a Supreme Court appeal. If they lose that, it sort of strengthens the hand of the Jan 6 defendants and their counsel in the future argument at the Supreme Court. But I don't think they have a choice but to appeal fully to the department, to the en banc full panel of the Federal Circuit Appellate Court if the Department of Justice is on the losing end of today's oral argument. I presume that the decision will come relatively quickly given the ongoing and current prosecutions and trial settings that will be happening in the winter and spring that involve these very counts. And if these counts are going to be ripped out and ripped away, it's going to set all these cases back as the defense and the prosecution scramble to recalibrate their respective positions. And of course, the ones that have already been convicted are going to be filing motions with the various trial judges where they were convicted to have those aspects of their decision and their ruling and the verdict against them ripped away and vacated, and maybe even ask for a new trial, depending upon how heavy the obstruction count played in the trial itself. That could be grounds for a new trial. So a remarkable set of developments today, and we'll have to just sit patiently and wait in the next week or so for the ultimate ruling. This is Michael Popok reporting on one of the key appellate rulings that is upcoming related to the Department of Justice's continuing prosecution of Jan 6 insurrectionists using the highest level crime that they have in their arsenal, which is obstruction, and its 20-year felony sentence.
MeidasTouch is unapologetically pro-democracy. And look, we know you are too. So please make sure you check out our best-selling shirt and our best-selling gear, the unapologetically pro-democracy gear. And hey, while you're at it, make sure you check out my favorite shirt and one of our most famous designs. It wasn't rigged, you're just a loser. At store.meidastouch.com. That's store.meidastouch.com.